All right, welcome to the Nottingham Zoning Board. I'd like to open the public hearing this evening on case number 16-006-AA. Application from Jason White, J&L Terra Holdings, Inc., requesting an appeal to an administrative decision made by the Nottingham Planning Board on May 11th, 2016. The decision in this is in regards to an interpretation of the zoning ordinance Article 2, Section C and Article 2C2. Property is located on Smoke Street in Nottingham and is identified as tax map 10, lot 4-1.
Mr. Chairman.
Yes, ma'am.
Before the case continues, I need to recuse myself as I am a member of the planning board. This decision is being intended to me.
Thank you, appreciate that. And so I'd like to seat in her place alternate Kevin Bassett. Excellent. If we could have a few moments for Terry to complete reading that.
Yep. No,
You good?
Yep.
Okay. All right. Mr. Landry, as you've sat on this board and sat before us at least a dozen times, I don't think I need to go over the rules. Do I?
Not on my behalf.
All right. I didn't think so. And since there's no one else in the room who doesn't have understanding, I think we're good.
There was one thing that I wasn't sure if you guys would have in your package or not. And I heard you speaking about that Doyle-Gilmington case, so I printed out the, it's not the whole, it's just it's like a Reader's Digest version. It's what they call an update.
Yeah.
And I didn't know if you maybe wanted to look, if nobody's looked at that case, it's somewhat important, and maybe 5 minutes you can take a look at that, and then.
If you're fine with
I'm
sitting
fine.
there.
Yeah, no, that's fine,
All right.
because I thought you may have already read it. I wasn't sure.
Doyle versus Town of Gilmanton. So Mr. Landry has given us the court update from the New Hampshire Municipal Association regarding the case which is referred to, Doyle versus Town of Gilmanton, number 2006-797, dated 7/19/2007. So he's submitted that to us, and I'd like to enter that into our data for the evening. Excellent.
Bonnie, this was what you were, this is a good synopsis of what you were asking for.
I figured that out, Paul.
Yep. Okay.
from the attorney, so then, I guess we're ready to hear your testimony.
Thank you, Mr. Chairman, members of the zoning board. For the record, Peter Landry, surveyor representing J&L Terra Holdings, Inc., on a proposed subdivision located on Smoke Street in town. Back in, a few months ago, we were at a planning board meeting, and we were going through the process of planning board approval, like we have in the past with other applications over the last year or so. And it was brought to our attention that the interpretation of how myself and Paul Kobe, your building inspector and planner for the planning board, have been interpolating the new zoning ordinance, which was passed a year ago. Now, that specific ordinance, as you mentioned, Mike, is Article 2CC, which reads, each lot shall have a 200 by 200 square fit for building, or a 30,000 square foot contiguous lot envelope, in which a house and a septic system shall be placed to meet all existing setbacks ordinances consisting of uplands. And then there's more to that ordinance, but it's irrelevant. And I did include copies of the complete zoning in the package. The second one goes on a little bit further, which kind of stems around the zoning change that occurred a year ago. There shall be between the property line, water's edge, and any dwelling a distance of 50 feet. Setbacks for accessory buildings, including septic systems, shall be 50 feet from the lot frontage or the front setback, and 20 feet on the sides and in rear. Okay, and there's more of that ordinance that's irrelevant. The fit for building, again, it's in that definition. We talk a little bit about it, but again, that's land that's not floodplain, wetland, watershed, drainage ways, or steep slope, 25% or more. Lot envelope is also mentioned in that definition, and lot envelope, again, talks about the 30,000 square foot upland buildable area, which is being designated as suitable area that can meet all local and state setback requirements. And then again, they talk about unfit for building, which is the opposite of fit for building. So a little bit more information within the subdivision regs, or the new subdivision regs. Article 8.4, specific plan information, number 17, asks the applicant, therefore the surveyor engineer, for the plan shall delineate potential building envelopes. Now, building envelopes are different than lot envelopes. We'll get into that a little bit more. And this wording is, I'm going to tell you what I think it means. I may be wrong, but it says plan shall delineate potential building envelopes for each class that represents regulatory and environmental restraints on the placement of the dwelling and other structures. I just think that means that, you have whatever the appropriate, that it recognizes different setbacks, buffers, etc., and recognizes they may be different distances. And therefore, you should show both of those distances on the plan. Furthermore, in the subdivision regs, a requirement for the subdivision, Article 18.2 talks about test pits, where the whole entire 4,000 square foot, which is a state minimum requirement they look for when you're creating a lot, must meet or exceed all applicable regulations. Okay, and again, we've talked about the setback for septics to be 20 feet. Okay, so again, part of that definition talks about building envelope. Building envelope is just an area designated, not even a given area, not a square footage area, but a space for newly created lots that makes it eligible for the placement of dwelling units. It doesn't say that the building envelope has to be 30,000 square feet. Right off the bat, it doesn't say that. It just says it has to be eligible or appropriate sized area. But then it goes back and talks again about the lot envelope, which is back where we've already discussed. It talks about the 200 by 200 or the 30,000 square foot in which a house and a dwelling is an accessory and your septic can be placed. Okay, So, how did we get here at this point? Back in, as a lot of you members know who were part of this committee that got together, Town of Nottingham 2014 Town Report from the Planning Board section states that the Planning Board continued to review the town zoning ordinance. 3 changes were explored in detail, and with one being selected for a warrant article in 2015. The proposed change will, this is a quote out of the book, will reduce setbacks in lots of 2 acres or greater from the side and from the rear property lines for accessory buildings, and later added in septic systems. The new setback will be no less than 20 feet from the property line. The change came about after a joint meeting between the planning board and our zoning board when they reviewed past case history in 2015. So a lot of this is not new news to you people. But that was what was proposed to the town of Nottingham, and as stated in the minutes of the annual town meeting for 2015, Article 2, are you in favor of amending the Nottingham zoning ordinance, section C2, residential agriculture district, which reads as follows? It talks about the 50-foot setbacks all around, is what it was prior to be replaced with the definition I already read, which talks about front setbacks being 50 feet, and added in setbacks for accessory buildings, including septic systems, shall be 50 feet from the front and 20 from the side and the rear. Okay, and the planning board recommended that 7-0 vote. Townspeople voted on it at meeting. It was 691 to 348 in favor of reducing the setbacks. Okay, so that's where we were in 2015. Now, the other night, we were, like I mentioned, at the May 11th planning board meeting, the board came up with a problem that they felt was now apparent to them, that maybe the way the 30,000 square foot lot envelope was being depicted on a particular application, the Smoke Street application, should not go to the 20-foot setback, but should stay at the 50-foot setback. Okay. Now, of course, I was at the meeting, and I've included the minutes of the meeting. You have the draft ones in there because the finals weren't ready, and then you should now have copies of the final minutes. But because I was there, I'm not gonna go down and read through there. My recollection was 2 specific reasons that the planning board decided they did not agree with my interpretation, as well as Paul Colby's interpretation over the last year of how we measure the 30K. So their reasoning is that according to, well, maybe I should read that so I get it right from the minutes. I'm looking at the May 11th, 2016 planning board minutes that talk about the attorney. Again, what happened was, let me just reiterate, the planning board had asked for a legal opinion on this issue. Paul had drafted a letter to a Barton mayor of Upton and Hatfield up in Concord, the town's attorney, asking him for some help or legal opinion. And the legal opinion came back to the town and was, as you can see from the minutes, I haven't been able to read that opinion yet. It's been portrayed to me, it's client privilege. So again, I don't have any reason to believe, I don't know what it says, but what I was told it says is that the attorney based his opinion on reading our subdivision and zoning regulations. Okay, that's a little unclear. What section, what is he talking about? But that's what it says. I was at the meeting, and what I was told at the meeting was that the attorney said that the town should be using the 50-foot setback or the more stringent setback, not the 20 feet. So that may be a little clarification. And as well as a case that Mr. Barton actually brought to Supreme Court. And it was the Doyle versus the town of Gilmington, which I let you read. Now, I'm not gonna go into a lot of detail on that, but what I understand is that the planning board made their decision strongly on the legal opinion of the lawyer based on this Doyle Gilmington, as it states in the minutes, being a very similar case. We don't agree with that. When you read this court case, I gave you the abbreviated, I have the full court case, and like Paul said to you earlier, there's a lot of other stuff going on, but this court case is not the same thing we're talking about here tonight. And let me just explain. This court case talks about an applicant going to the planning board and coincidentally, this looking to have the town required a 30,000 square foot area. The applicant thought they could measure that 30K up to, say, the property line or up to the edge of the wetland line, and including the setbacks. That's what the applicant thought. That's not that far-fetched. This town used to do the same thing. We used to have the 60K area in the 200 by 200 used to go right up to the lot lines and right up to the edge of wet. Over the years, it's been changed to 30,000 exclusive of setbacks. That's where we were before this last change, where we reduced the setbacks. But this Doyle Gilmington talks about the applicant wanting to include the setbacks. This whole thing went to Superior Court, Supreme Court, and the outcome was, and it's right in here, was that because there are setbacks, you have to measure 30K to the setback. Okay, nobody's disagreeing with that. We've been doing, that's what we've done, always done that. We'll continue to do that. The question is, what setback? Is it the 50 or is it the 20? So, again, I don't feel that there's any real similarity between this case and what we're discussing tonight. They're two different things. I don't understand how there's any similarity. Okay, so, but that's what the planning board obviously did, and they gave the legal opinion, they put a lot of weight in that legal opinion based on it being very similar to Doyle and Gilmington. According to the minutes, I hadn't been able to read the letter. Okay. So, the decision that the planning board made left my client aggrieved. Obviously, that was our invitation to the zoning board. The board made a determination that the 30,000 envelope must be measured to the more stringent or more strict setback. Okay? Not the allowed 20-foot setback, which we just reduced it to. The board also stated that although septic systems were now allowed to be constructed 20 feet from the lot line, there were no other changes that occurred as of that last zoning change we had in 2015. Which doesn't make any sense, because we reduced it to 20 foot for accessory buildings and septic, perfectly clear. So, why we feel the planning board made a mistake in their interpretation of this ordinance. Again, 2015, the town people of Nottingham voted to reduce side and rear setbacks to the property lines for accessory buildings and septic systems, 50 to 20. Okay, and that was based on the warrant article that the planning board and the zoning board worked on. Okay, I wasn't able to find any definitions in our zoning or subdivision for accessory buildings or for septic systems anywhere in the subdivision or zoning. Perhaps the boards felt that these structures did not need to be defined any further, that they were pretty obvious. There's a reference I had mentioned earlier of the 4,000 square foot for the septic reserve area in the subdivision regs, which talks about the entire 4,000 square foot area must meet or exceed all applicable regulations. Okay. It would seem very obvious that if a septic system would include any part of the septic system, the leach field, the septic tank, the piping, and the current setback in this town was reduced to 20 feet. And as I mentioned earlier, the 30,000 says it shall, not should, not will, not won't, shall include the dwelling and the septic in the 30K. They're gonna be together. I didn't find any definition for accessory, but I went to Black's Law Dictionary, which defines accessory building as structures used for the benefit of the main building, tool sheds and outbuildings, garages, that kind of thing. Using this definition, if the accessory buildings are a part of and benefit the main house, garage, shed, then why wouldn't the accessory building be allowed to be part of the 30,000 square foot, which is now allowed to be up to 20 feet? We're being told, no, that has to be 50. And everything else, your 30K has to be measured to the 50-foot setbacks, but that extra 30 feet that will allow you your septic has to be 50 at the planning board. It's just confusing. I don't even understand it. That's why we're here tonight. So, again, to maintain some consistency in the rules, when the people of the town voted to reduce these setbacks to 20 feet for accessory buildings and septic, it would seem reasonable that these new amendments would have to apply to any other section applicable in the zoning and subdivision regs that controlled the placement of accessory buildings and septics. As an example, before the change, septics were 50 feet from the lot line. Garages were 50 feet. As you guys know, special exception allowed you to come 20. That all went away when they reduced the setback to 20. One of these sections of the zoning that was affected again was Article 2 CC, which is the reason we're here again tonight. Each lot must contain a 200 by 200 fit for building or 30,000 contiguous area lot envelope, building envelope, lot envelope, in which a house, septic system shall be placed, okay? Seems very clear that each proposed lot would still need a 30,000 square foot contiguous lot envelope in which a house and a septic shall be placed to meet all existing pertinent setbacks to the stated structure. Now that accessory buildings and septics are allowed to be 20 feet from the property line and the house and the septic shall be placed to meet existing setbacks within the required 30K lot envelope, it would seem reasonable that you would allow us now to extend the 30K to the 20-foot setback. The reduced 20-foot setback only affects accessory buildings and septic system. The existing 50-foot setback from property lines to the main dwelling still remains. That hasn't changed. That's the part I do agree with the town attorney. He states that dwellings have to be 50 feet. We agree with that. Nobody has ever tried to put a dwelling less than 50 feet. That's always been Nottingham's rules, and that hasn't changed. So after that 2015 zoning change, I talked with Paul, as well as other applications I've done in this town and got approved, about how we'd look at this 30,000 square foot could be measured. Well, I asked Paul, we discussed the 30,000 square foot, whether or not, if he thought, in his opinion, as the planner or the reviewer, he thought that now meant we could extend or stretch that out to the 20-foot setback. And we've never disagreed. We don't think Paul's done anything wrong in the last year. It wasn't until this last planning board meeting that they told Paul and myself that we were doing something wrong. We thought we were doing everything right, and I still agree with that, based on the way the wording is right now. So during that process, you'll see that I've included other examples in this package of some other subdivisions that have been, already gone through this planning board, been approved, and are recorded at the registry of deeds, right now, and what they show is each of these subdivisions shows the minimum 30,000 square foot fit for building to within 20 foot of the lot line, just like the rules say you can. It also shows a second setback line, like the rules tell you to do, that shows the 50-foot setback. So you now have to show two setbacks. You gotta show a 50 and a 20. And you have to show that the dwelling meets the 50-foot setback all around, like it always has. Which what the town has done is by reducing that setback to 20, you've just allowed us to stretch the accessory and the septics out to that area, and therefore that's part of the 30K, so that should be allowed to the 20K. I mean, to the 20-foot. So, let's see. Okay, yeah, well, that was something, one thing that, again, I'm gonna just repeat, it's a little bit of repeat, because I wanted to introduce you to it first, I'm gonna show you how it applies. That subdivision article 8417 talks about each plan delineates a potential building envelope, which is different than lot envelope, for each class or each setback that represents the regulatory environmental restraints, whether they're buffers or 75 from very poorly, 50 from poorly, they're all different depending on what you're setting back from. Should be shown on the plan, and that's what we've done in the past year, since the zoning has changed, and that's what we'd like to continue to do, and that's the way that, again, Paul and myself have interpolated that. So, in addition to the lot envelope, like I mentioned, the applicant has to delineate a potential building envelope, which you've seen in those examples that I gave you. And the plan meets, showing that they meet the appropriate setback. And nowhere in your definitions does it talk about a minimum area, square footage area for a building envelope. It just talks about being 50-foot setback from the lot line.
But doesn't it,
There's building envelope and there's lot envelope. There are two different things. And the building envelope doesn't talk about a specific square footage area. I only mention that because the attorney is stating that the 30,000 has to be measured 50 feet from the lot lines. And again, if you're 50 feet from the lot line, now we're not talking lot envelope, we're talking building envelope. And I didn't see that in here. And I didn't see anywhere in these rules where it says I have to go to the most stringent. It says I need to use the appropriate setback, which that's telling and recognizing that there are different setbacks that apply in different situations, depending on what you're set back from, or to. So, you know, unlike the 30K lot envelope, like I said, there's no minimum area for the building envelope. And this is somewhat consistent with other sections of your zoning. In Article 4S8A, you have open space standards and conditions, your clusters, okay, your open space developments. Now, which allows for a new lot, and so you're creating a new lot, just like we're doing on Smoke Street, except we're doing a conventional down there. You're doing an open space, you're creating a new lot, your setbacks have been reduced to 100 foot of frontage, with a 30,000 square foot lot. That's minimum lot size, okay? And then you have to exclude the 35-foot front setback and the 25-foot side. So as a quick, we're in a gravel pit, best soils, no slope. It's a 100-foot by 300-foot lot. There's your 30,000. You exclude your setbacks. You're left with, for your house, your septic, your well, your driveway, your improvements, you're left with 12,000 square feet. Okay, pointing that out. Conventional, now being told, we need to have 30,000. But on an open space, you can have 12. And you'll see some sketches of that in my packet that shows some examples of what I'm talking about as I'm going down through it. So you could now take that same philosophy and look at it at a 2-acre, you know, prior to the zoning change in 2015, a typical 2-acre, let's just say, again, perfect site conditions, no wetlands, no nothing, So 200 foot of minimum frontage would end up being 435.6 feet deep to make the 2 acre minimum. And before 2015, we had 50-foot setbacks all around, okay, which was everything, which ended up leaving, out of the 2 acres, 33,560 square feet of usable area without asking for relief from the town to build on your own land, which I feel is the reason why the boards got together and reduced the setbacks in the first place. So, again, we haven't changed density, we've just changed setbacks. You still require 2 acres in town, you still require 200 feet. You've reduced the setback from 50 to 20 on the side and rear for accessory and for septic. Those are part of the 30K, and what you've essentially done is allowed a landowner with a 2 acre lot in town, 200 foot by the 435, when you reduce that setback, you've now allowed him to use 58,496 square feet of his land without coming to this board and asking special permission to do something on their own land. Okay, so you gave back about 20,000, 25,000 square feet of land back to the homeowner that he can now use and meet all the setbacks and not need special permission to do something on his own land. And I think that's what kind of was the intent of what the whole change, the action to change or reduce the setback was all about. So that's pretty much all I've got to say on this. I hopefully haven't gone too long where it's more confusing, but to me, this is a pretty straightforward situation. I don't know why we needed to have the lawyers involved, to be honest with you. I thought Paul did a wonderful job. I don't think it's so confusing, although having said that, let me just bring one other point up. Maybe it is confusing, otherwise we wouldn't be here, okay? So I do want to retract that, and I do want to go back to the minutes, because there was one thing that the attorney did say at in one of his ending suggestions, is that the attorney suggests a language change. Okay, so Mr. Colby replied that the attorney said the more stringent setback requirement is the 50-foot setback for the 30K area for the dwelling. This, which is true, nobody's arguing with that, except we'd like to go to the 20 because of the accessory structure, which isn't part of this, but the setback was not changed. The setback was, septics and outbuildings can be placed within 20 feet, and then the last sentence says the attorney suggests a language change for the future. So I think, he asked us opinion, he gave you an opinion, he based it on a court case which isn't relevant, and now he's saying, you guys got some more work to do. If you don't, well, you might have some language changes here or some wording that needs to be looked at if what way we're interpolating the regulation now isn't the way that the town intended it to be interpolated. So, that does it.
All right. Any other folks in support of or favor of the applicant wish to get up to the table and speak?
You can sit next to me.
Chris Albert, 36 Stage Road. I've been a resident of town for 29 years now. I was on the planning board for 5.5 years, chairman for 1 year. I'm also a consultant in town for a private company. I'm a wetland scientist, septic designer, and I do have a vested interest in that we have a case predecessing Peter's case, again, working with Paul. Again, we did work with Paul in the interpretation of the setback. I was present when we all voted last year for the 20-foot reduction, all thinking that was the intent. So my interpretation is what the attorney has done is contrary to the spirit of what the voters went to vote for last year. Your town building inspector and planner has worked on that good faith. Plans have been presented in the last year recognizing that, and I just feel it's in bad faith as far as what's transpired in the last month. Thank you.
Anybody else? Thank you, Chris. It's seldom that we get a guest speaker. Mr. Anderson.
Yeah, just to, I support the applicant in this case, and,
Can I stop you there for a minute?
Sure.
Are you here as a planning board member or as a private
As a
citizen?
resident.
And a developer slash
me?
builder?
and,
Just what hat are you wearing today?
okay, I'm wearing the hat of resident and builder,
Okay.
and what I have seen is, actually, I think this is clearly an interpretation, issue, and I think that, you know, when there was a change in setbacks, addressing, accessory buildings and septics, that, whatever, the actually meaning of that was, may have been misconstrued, and what I do see has happened is that, have been, subdivisions that have gone through following, yes, the 50-foot dwelling setback, but also going in accordance with the 20-foot setback, using that, building, envelope to, come up to the 20-foot setback, boundary, and, I just think that whatever's happened here, whether it's been caught, as a mistake, or whatever is really going on, what it's doing is affecting, cases that have already gone through, and then also in the works, so just wanted to mention that.
Thank you.
Thank you.
Any folks in the audience against? All right. I guess we can close the public hearing piece and then have our deliberation conversation.
But we'll still be able to talk to Peter, right, if we have questions now?
I
Or do
guess
have
we
to
could
now?
reopen the public hearing if we needed to address him specifically. Do you have a?
I
do you
just
have
had
a
some
question?
questions, yeah, I had some questions, I
Yeah,
didn't wanna
let's
close
get
it
that
up
done.
real quick. So, this is opinion from the lawyer, you didn't see it that night of the planning board?
This is protected by
No, I'm not bringing it
client
up.
attorney
Right,
privilege, right?
right, but I'm saying that night of the planning board, you knew nothing about it. You didn't,
Well, I knew about it, I was told I couldn't read it, but I had asked, at
No,
the
no,
public
but-
meeting, I had asked if because I wasn't able to get a copy of it, I was
Right.
at the meeting.
so
I
you
was
were
asked-
not prepared at the meeting?
No, the planning board meeting before that, they said we need a legal opinion. They got the legal opinion and it continued the case.
Which
Planning board cases drag on way
Oh,
longer.
no,
than
no, I
ours.
know that.
No, which we weren't ever able to read the opinion. We asked for it to be read at the planning board meeting, and we were denied through client,
Privilege.
attorney privilege, which, and, then of course we had asked for copies of it, because I'd like to have seen it and, see what he had to say, but I'd never seen it.
But you did get a summary, which,
A verbal, that's all I could give, that's
right,
according to, Bart. Yep,
and the verbal summary was, can you repeat it again?
pretty much Pete, what his summary were accurate is what the minutes, I mean, yeah, that's,
Okay.
he was accurate when he
All right.
reported tonight.
Right, but after you read the Doyle case, and you have explained to us tonight, that it did not include
At
setbacks.
that night, yeah, that's a good point, Terry. That night I hadn't read
Right,
the
you had not
Doyle
read the
case
Doyle
at all.
case, so you could
And I
not-
was sort of going on just going with the flow about the Doyle case, that
Right.
it did pertain it wasn't until I read it myself.
Right.
And made my own mind up that this isn't the same thing.
Right,
That was
so
my opinion.
it wasn't apples and apples,
believe
it
was.
was apples and
No,
oranges, completely
absolutely.
different, right, okay.
In the Doyle versus Gilmington case, the part that pertains is, that is considered attorney-client privilege, so we can't, the letter. Okay, but as Pete was saying earlier, what the town of Gilmington used to do, is you can see, this is the actual plan that they're discussing tonight. He's showing the 20-foot setback. What Gilmington was doing was counting this area this area, and this area is part of their 30,000. That's when the court says, no, you have to subtract that. In this client's case, he has never once calculated the setback lines in the area.
Right.
And my interpretation was, and I've been leading these guys, not just Pete, Chris can say it, and his other guys have come in, 30,000, and this one's over. But he does show, it's hard to see on this, a 50-foot setback for the house. So,
No. I had just a couple of, how many subdivisions have gone through with the 20-foot setback being used?
You
Other
should
than
be in your
just
packet
Peters?
right
But-
there.
Well, are they just Peters?
Are they just mine, or I can only speak for myself,
Right, but I'm
Terry.
asking-
I didn't do enough research to see if there were
Right, I'm
others.
just wondering if there were other
I don't
subdivisions.
know.
I will say this, without looking back at the records, Terry, in the last year, except for the ones that Chris has in front of us, as well as, oh, you've got another one. And Peters, for your personal subdivision down on
We
your
used a
land.
50-foot setback.
You did use a 50-foot. He's been, you used Roscoe? Yeah, that's the only subdivision outside of Peters that was in
Okay,
front of the
so,
board.
I mean, this came through in,
Oh, I'm sorry, Roscoe, we do have another one currently in front of the board too, that,
with the
Pete
20
didn't
foot.
do.
Oh, okay.
No, they're doing 50 foot because they want huge lots. They purposely are designing it for
Want bigger.
large areas.
Okay,
Yeah.
So this passed, I mean, 315, and so there's been a few subdivisions have gone through with the 20 foot. I mean, the planning board had up till January, they could have put amendments in to straighten out the language, right? I mean, that's when you normally, I mean, the planning board had an opportunity to straighten out the language if they thought there was a problem, right?
Yeah, I would say that would be correct.
Yeah.
Any other questions for Mr. Landry?
Yeah, could I just
Yeah.
get a clarification on that? Constricting numbers. The ordinance went in place on a certain date in and around March,
Correct.
and the new ordinance was in 2015 or 16, new setback,
Well, the setback was in March of 2015.
15, right.
15.
15, yeah, the 15 town meeting.
Okay, so since then, I just heard you say that there have been numerous
Yes.
means
Many.
more than one.
Oh, absolutely. I would say we've had, well, we've got,
I
what,
gave you an excuse me, but I gave an example of 5 lots
Five.
in the package, Kevin,
right.
that I was personally involved with.
Okay, okay. Okay, thank you.
Peter or Bonnie?
I don't have any questions for Peter, but I hope we move to discussion.
Yeah, I have a few comments, but no more questions.
Okay. At this time, I'd like
Peter's
to
very
close the
thorough.
public hearing on this matter. And if you guys have questions of Paul, I have one, but I can wait. I'm a patient person.
Well, in trying to sort this out, it seems to me that there is indeed some confusion in the language of the ordinance. And when the setback was changed, reduced from 50 feet, I don't think anybody went over the other language. So the question is, does the lot envelope language and the building area language apply to residences? And I think it's clear that it does. I don't think, normally, it would apply to accessory buildings in the same way. In other words, the new language says 20 feet for accessory use, not for residences, not for dwelling units.
That's correct.
But there could be accessory use buildings that have septic systems that are even separate. I think of my own building, I would love to put a septic system in there when I win the lottery and have a bathroom. And it's really, too low from the existing septic to pump up to it. And probably would be better to have its own. So I can see where the 20-foot setback for septics would working, would be, you know, possible, and still maintain the 50-foot setback for the lot envelopes. I mean, there's probably no question that the ordinance needs to be reviewed, and these two parts tweaked. But it doesn't, to me, it's not perfectly clear that the intent of the change in the ordinance was only for septic systems that serviced dwellings, because there are plenty of accessory buildings that have septic systems, that have offices in them or whatever.
Well, the change for the 20-foot setback wasn't just septic systems.
I know, the
Accessory
reason,
buildings.
Right.
the reason this board, I believe, was in favor of it, of most of the changes, was because we do get a lot of setback cases.
Absolutely.
But they're not, I don't recall, I don't know how long I've been on the board, but it's probably 5 or 6 years. I don't recall ever getting one for a septic system.
No, it's.
I recall getting them for decks, for garages, for things like that.
Sheds.
Sheds, barns, but not septic systems.
That was the original intent.
Yes, can I,
And so, at least that was our concern.
Before the zoning change of the 20-foot setback, setbacks for septics had to be 50 feet,
Right,
okay? The state allows 10 feet, it's state law,
right.
okay?
But at the same time, just let me interject
Yep.
here. There's multiple court cases where a town can be more restrictive, but not less restrictive than the state.
That
So
would
we
be
don't have
correct.
to hold to the town.
No.
We can
Right,
make it
and
whatever
we
we
settled on
want.
20, and why we came up with 20 was to reference the cluster space. We allow, the argument used to be, well, we have to keep septic 50 feet from the lot line, so it'd be 100 feet between mine and your septic, say. But if we lived in a cluster subdivision, our septics are less than half of that, because they're allowed in the zoning. So now we're taking a 2-acre lot and putting the septics 100 feet apart, when we could do a cluster subdivision and allow them to be 50 feet apart.
Do our
Give or take.
clusters allow, separate wells, or do they have communal wells?
Separate wells, as long as they can prove they can get the well and septic
What
on
is
the
the
lot.
setback from a septic for a well? Is it 75?
75 feet, yep. And we've had 2 approved, and we're looking currently at 1 more in front of us right now, in front of the planning board, for an open space development, cluster subdivision. Right, with reduced acreage. Yeah, and Pete's right, in our new subdivision regulations, which the planning board adopted last year, there's a difference between, there's a legal difference between building envelope and lot envelope.
Yeah, so I noticed in our zoning ordinance, we define lot envelope.
That's
and
right,
it's-
we don't define building envelope for this reason. I could not convince the planning board to add that to the ballot last year. The goal is to, all our definitions, I don't care what document we have,
Right,
are consistent.
yeah, I remember you saying that.
Right, and we're in the process of still doing that. That's on our list to change, hopefully for next year's town
So
meeting.
can you read into the record the definition of a building envelope?
Building
From the
envelope.
site,
Yep.
this is from the site plan regs,
Subdivision.
subdivision.
Subdivision regulations. Building envelope shall mean the area of a newly created subdivided lot eligible for the placement of dwelling units. Building envelopes are restricted by operation of local, federal, and state law and can be further restricted in the location by operation of a subdivision approval to enhance the purposes and further the requirements of these regulations. In summary, what that means is, a developer has to prove to the planning board that this lot, whether it be 3/4 of an acre, 2 acres, 5 acres, 100 acres, is suitable to put a house and its auxiliary functions, driveway, septics, wells, etc. Okay? The local ordinance would be our setback ordinance. Okay? Now, if you look at the definition of a lot envelope, it is a 200 by 200 foot square or a minimum of 30,000 contiguous foot upland buildable soil area depicted on a plat or building permit, which is being designated as a suitable area that can meet all local and state requirements. The 30,000 foot contiguous square foot areas shall also be of adequate width and or depth as to not create an hourglass effect of less than 50 feet at the narrowest point. The lot envelope shall include either areas the lot envelope shall not include either areas unfit for building and their appropriate setbacks or building setbacks. Unfit for building would be wetlands, steep slopes, things like that. So we, as Pete testified, we have different setbacks depending on that, in the building setbacks. So, and as we said, you know, that was the Doyle versus Gilmington case that they used to calculate, which this town has never done since I've been here. So, again, a developer needs to show to the planning board on that proposed lot, doesn't matter what size the lot is, outside of open space development, that there's 30,000 square feet of buildable area on that lot that meets our setback requirements. My interpretation has been our setback requirements are 20 feet, as long as they can show the 50-foot setback within that 20-foot setback envelope, as he drew here.
I mean, the 50 feet for the actual
For the
house.
actual dwelling, because that would be the dwelling setback. No one's arguing the front setback, no matter what the building is 50 feet.
Right.
Everybody adheres to that. So,
Mr. Chairman,
Yes, sir.
from what I remember, this discussion was mostly to bring relief to existing lot owners who were coming to the ZBA for these changes. There was no discussion in changing our subdivision regulations. There was not one word mentioned about changing our subdivision regulations.
Right.
And I think the attorney is correct.
but the subdivision regulations would not come to your board at all.
Well, the town never voted to change the subdivision.
Subdivision regulations do not take a town vote. By law, the planning board holds a public hearing, and they adopt subdivision regulations as well as site plan regulations.
Well, they haven't changed them either, have they?
Yes, they have. As of September 2015, we adopted new ones. I wrote a whole new subdivision
Different
regulations.
setbacks and everything? With the different setbacks? and everything?
Setbacks do not go into subdivision regulation, they only go into zoning ordinance. It's two separate independent articles that do have a tie.
Right.
Right. And the same thing, we're up in the process of updating our site plan regs. The only vote citizens get is on zoning changes, not subdivision, not site plan.
Right. The planning board proposes them, and then the town people vote on them.
Right. Well, anyway, the spirit of this change we made last year, we didn't even discuss subdivisions during it, was to help the existing property owners who had lots that had a hard time fitting their accessory buildings in, and once again, we've never had a septic system issue.
This board may have not discussed it, but it was discussed on the planning board level in the public hearing, because they're the ones that have jurisdiction over this.
Right.
I think
So
this would change the character of our subdivisions if we did this, and I think we'd take a much more thorough public discussion before we make such a wide-ranging change. I mean, once
Yeah,
again, I
I
don't
mean,
think that was the
we
intention.
followed process. To me, it got politically hijacked at the planning board when the discussion in the public hearing came up. I wasn't happy with the outcome, but the outcome is the outcome. I think we've also, let the fox in the hen house to some extent, by adding a to me, a septic tank and a leach field is part of the primary structure. I know you argue against it.
Under state definition, under the building code definition, you were wrong.
But could you buy a house without a septic tank?
Sure,
Really?
I have a house like that, I'm on town sewer.
Well, with the
You
exception of with the exception of a sewer, could you get a house without a sewer or a septic tank? Or,
In New Hampshire, yes.
How?
They are, outhouses are allowed, you can have a dry well for gray water, that's not a septic. Technically, it's not a leach field septic tank, so yes, you could.
Live free and die state. I like it.
Is it right? I don't know, but state law. you
Right.
can't.
But, you know, when we went out to the 20-foot, we allow people to put, you know, these open lands, the subdivision with the small lots, I mean, those systems are so little, they're gonna fail. They're gonna fail very quickly. You can't even get a stone and pipe system on those, probably on those lots. And that's the best system you
cluster
can get.
development.
And the cost of development, yeah. So allowing the 20-foot setback on the 2-acre lot allows people to put their systems 20 feet from the line. You can put a good stone and pipe system in, a system that will last and protect the environment and not go into failure early.
So basically, your decision tonight is based on, the planning board has made a decision to follow our town's attorney's opinion.
Right.
You've heard testimony from the applicant saying he believes the planning board erred in their decision. And now you five can decide, did the planning board decide correctly, or is the applicant got a valid point?
Yeah.
That's really the bottom line in this.
Yeah.
Planning board has already known that we have to address this issue at next year's town meeting. There's nothing we can do before that.
Right, no, I understand.
Except send people to you.
Right.
That answered one of my questions. Ordinance can't be changed until,
The zoning ordinance can't be changed until March of 2017, correct?
But it could have been changed in January or December, right? I mean, they could have,
And what the issue is,
Planning board already changed.
from the town attorney, you guys have your zoning ordinance, or Pete supplied you a copy in his package, is Article 2, letter C, 1C, where it says each lot, that's where it talks about each lot must contain 200 by 200 or 30,000. I'm gonna paraphrase if it's all right. In which a house and septic system shall be placed to meet all existing setbacks. His interpretation is, the next, number 2, in the next paragraph, is where we change the actual 20-foot setback. Because everybody failed to change that letter lowercase c, his interpretation is a normal house setback is 50 feet. So that's why the planning board had to calculate the 30,000 versus 50 feet.
there's a word that's an A-N-D, house and septic system.
Mm-hmm.
That's the key, that one little word. It ties them together.
Well, a septic system can meet, the existing setbacks for a septic are 20 feet. That, nobody's arguing that point.
But
The point
in that
is,
one paragraph, it ties them
Right.
together.
Right,
right,
right, but it could tie
That's-
it together
and
for the
that's-
good.
That's the
And that's the-
confusion.
right,
If that said house.
Right.
Didn't say septic, and then the next paragraph it says including septic, is separated. One
his
could be
basically,
one could be 50, one could be 20.
right. Are they married or are they divorced?
from our
I
attorney,
know what an and function and an or function is.
from our attorney, he proposed, there's 3 ways to handle this going forward.
Yeah,
Number 1, on number 2, where it talks about the actual setback number, changing everything on side and rear to 20, or 25, you know, we can change it. If it got changed to 25, it meets what the setbacks are for open space. Or, in that lowercase c, eliminate the words, in which a house and septic system shall be placed. It's just square foot area envelope and I'm gonna, I forgot, I don't have my notes in front of me on this. So you take out that statement in there,
Yeah.
and now it'll clear up the language either way, so people could interpret the 30,000 as 20. He says, unfortunately, when the planning board sent this to, town meeting for their vote, they did not change this. The other unfortunate thing is, every zoning change since I've worked here, up until last year, was always sent to town attorney to review.
we didn't send this one.
It was requested, and I will leave it at that. The current administrator did not send it forward, as well as other issues. So this might have got red flagged, as you were talking about, Peter, way back when.
Right, it's like we can't expect our planning board members to be attorneys.
Right.
Right.
So that's why any zoning changes that, since I've been here, and even look at the records before, have
Yeah.
always gone to the attorney for review first.
Yeah,
We were told it did, and come to find out,
did.
So I think I would favor a cautionary path here with the zoning board not changing. Because we don't really know what the intent of the board was until they figure it out. Because the way, you can interpret it either way. So if they wanna change it to allow, they have to make that more clear.
But they've already allowed.
But they've disallowed,
Subdivisions.
they've
What's that?
disallowed.
Yeah, but they've
It
allowed
just-
too, so.
Conflicting
Well,
there.
that's conflicting and it's very confusing. I can see why you guys are confused. So, to me, I go back to, by relieving, the septic area to the 20-foot setback, we create a takings issue. Because now you, by placing your septic that close to a property line, that restricts me on the other side of that property line from where I can place my well.
No, when you put a well, your well has to be within the lot, or you have to sign a release.
Right, but.
So that's, you
Well-
haven't restricted yourself at all, that's the way it goes.
Well, I
That's a state
disagree with
rule.
that because, I mean, I would never waive my dimensional requirement. I would always want to be at
Well, then
least
you have to
75
keep
feet.
your well on your lot.
Right, but no, my
Yeah.
well would be on my lot, but your,
It would have to be 55 feet away
It would
from
have-
your lot line,
Right.
if they were 20, so.
right,
So it makes you have the well further.
right. Yeah, if you have your septic
Where it could be
up to
20.
up to the 20,
Yeah,
right? That means I've got to go 55 feet in, not 25. You see, there's a
For what?
35 foot
The
take.
thing is, that's gonna be hard to argue in court, because what's
what,
gonna
a
happen,
well
the
or
defense
your-
lawyer is gonna
Well, this-
argue, the state allows 10 feet. Yes, you can be more stringent, but the less stringent is already recognized at 10 feet.
So I agree with you. I think this is an issue to me, this is an issue for the Supreme Court to decide. I think somebody's made an error on the 10 feet. I think we're also creating an error with the 20. That's my opinion. I know it differs from the builders in town. But I'm looking out for the public interest.
You gotta
And I
remember,
think
how does a septic work, Mike?
hopefully
It
well.
goes down, it doesn't
it
go out.
really goes down.
It goes down, doesn't go out.
You can dig a foot away from a septic system, you'll
Yeah,
see nothing.
Okay,
Yeah.
so Paul, how does a well work?
Goes down.
It draws from underneath the septic in a cone outwards.
Right,
So-
so a septic is designed not to go that deep.
Right. It's designed to
We
purify.
hope.
That's why it has to be 75 feet away.
That's from the wellhead.
Right,
May I
yeah, certainly.
get back on target here? Is it possible to get new wording for these that might be proposed next March?
Yes.
Not at tonight's meeting.
Not, I
They
mean,
can't.
the planning board has it on their,
Not at tonight's meeting.
No, I didn't,
no,
I
right.
didn't put a time frame on it.
right,
Yeah.
the
Is it
planning
possible?
board has a list of zoning changes, and later on this summer, this board will be invited in sometime to make recommendations. And then the planning board will go through their process of making changes, right? And they've already recognized this particular issue has to be addressed.
Sure. So
So let's wait for
I
that
could
to
feel better about it if I saw words that were appropriate, changing this, that may be in the best interest of the town, and then maybe some agreements from the same lawyer, so. Okay. Preliminary, red line,
Yeah.
what have you.
Yeah.
I would feel better if I saw that. Is that a reasonable request?
Yes. One night.
Now, that's time, obviously. I don't know how long that would take versus the applicant.
Well, it'll be after next town meeting that any change will
Well,
be approved.
because you're also gonna,
But it would be at least something that would be put forth at that time, that we could say, yea, verily, we're making a decision based upon something, even though it's not in concrete, it's still in the same interest that the town voted on, same kind of scenario, you know? There have been many, many steps to get to this point. Many of them are appropriate and, we're focused on a solution, per se, or change. And if that change didn't come to play in the wording that we see, then new wording is just needed to get to that same point that was voted on, desired, planning board, et cetera.
and the word of caution that I always give the planning board, if they propose a zoning change, as soon as they post that change, it takes effect immediately, even without town vote. Now, what happens comes in March, if the town votes it now, everybody that's followed that new rule say, sorry.
Right.
But, so that's why towns in general traditionally don't start publicizing zoning changes until
The last.
end of the year.
Would it have to be publicized, or could it be board to
They have
board?
to have a hearing.
No, the planning board can start working on it now.
Yeah.
But right now, we have such a high caseload, and we've got at least 3 commercial site plans coming in. And we're in the middle of redoing the site plan regulations, and they know that for the month of November, I'm gonna be out of the country. So we're trying to get this all up to date before I leave, and then they can focus on zoning.
And usually they
Next, traditionally, we don't even address zoning to end of October, beginning of November, because the public hearings are the 1st of January.
Right.
Yeah.
So we're trying to do, are we trying to do those early, or at least get the groundwork done?
At least get the
early?
groundwork after we get through, we've got many applications. So I mean, if this board, any of this members have suggested language, please submit it to Joanne or I. But never mind the whole well issue, let's,
Yeah.
So I'd like to make a
Certainly,
motion.
the applicant's, note about defining a few more things. You know, you mentioned, you know, septics and sheds and, you know, where they may not be defined in an entirety.
actually, what the planning board had decided, they're defined auxiliary dwelling in the building code, which is state law, so that's, they went with that. Give you the history on that, yep. So, that's one of my proposed changes, to add that definition into our zoning with the lot, the 2 different lot issues.
Kevin, would you like me to write a memo to the chair of the planning board? You know, just giving action items that need to be addressed after the outcome of tonight's meeting? And I can CC all the board members.
Well, certainly.
We can have input.
Yeah. If I miss something.
Mr. Chairman, I'd like to make a motion.
Okay.
May I? I move that we deny this application and uphold the decision of the Nottingham Planning Board.
Any second?
I'll second that.
All in favor?
Aye.
Aye. All opposed?
Excuse me, Peter, you seconded?
Yes.
So, just so I gather the facts for the memo, Kevin, one is the building envelope definition. Is there a reason that couldn't be, well, you've already said that the intent is to change all the definitions to be in all the articles.
Right, yeah, so we've got a list of, in our new subdivision regulations, no, the new site plan regulations, we're just swapping. But the new subdivision regulations, any, definition that's in there that pertains to zoning, like this issue,
Right.
we're gonna transfer it. Now, if you, some of the definitions in zoning aren't in subdivision because they don't pertain to subdivisions. It's- Right.
So really, to me, it would be, one bullet point on that memo, and that would be for us to go through and clarify between the definitions and the shalls and the ands, all the language that were impacted by the rule change in 2015.
Certainly, that's a good global bullet,
Yeah.
yes.
And then that needs to be reviewed by attorney before we put it before the voters.
That would certainly be our recommend, the recommendation of another bullet, sure, as far as I'm concerned.
Yep.
You know, the sub-bullet to that is, yes, we need more definitions, but definitions on what? And so we'll wait and see what they do. But
Yeah. So one thing I noticed, I don't know where this fits in, but the building envelope is defined as a 200 by 200 foot square.
Right.
And you get automatic relief down to, of 10,000 feet, down to 30,000 square feet by making it in a regular shape. So you already get
Kind of
rid,
inconsistent.
That has been my argument from like 12 years ago when I started working here. I'm like,
so like,
we need to make the numbers equal.
right,
Yeah, so,
Otherwise, they're inconsistent.
and I've been suggesting that 200 area,
yeah, why do we make the,
I guess way back when historically, it used to be 200 by 200.
Right, and that included the
1
setbacks.
And that was all the way to the lot lines.
Right, all the way to the law.
And when this got changed, they're like, oh, no, we want to leave that. And I'm like, but we're doing this in our own paragraph.
right,
Yeah,
you get automatic relief of 10,000 square feet like that.
just like that.
Right, by
And
making a
30,000
trapezoid.
is the recognized buildable area in rural towns in New Hampshire.
Right.
I mean, that's the town I live in our residential agricultural zone, it's 30,000, so.
So you've probably already made that recommendation, I don't need to bring it
But
up.
still, it's good to remind us, because
Okay. You
I
have a lot
forget,
of-
she doesn't, I forget.
So Paul, I heard you say you made red lines to this.
Yeah, I mean, we've got a note.
Can we see what those red lines are, and then possibly add.
Absolutely.
Is that?
Joanna will send that out to you.
Is that a reasonable
Yeah.
question? Is that a reasonable thing for this board to do?
Yeah,
And that actually makes sense, Kevin. That
helps
way,
us.
if you already see on the list, okay, I don't have to write that one down.
Right.
It's already being taken care of, right?
I fully expect that you're, God, most of, your red lines would probably be pretty solid, put it that way.
I try, but I
To
miss
see 'em
stuff.
would help,
Yeah,
it's
would help
complicated.
absolutely, yeah.
know what is in the future or proposed future
Right.
that would go forward with.
Yeah. And updating the site plan regulations too, and a lot of people going, well, why are you focusing on that? Last time it was updated was 1998.
That's why.
I was just in diapers then, but, be quiet.
Sorry about that.
Yeah. But the whole idea is why we haven't really focused a lot on zoning too was, once we adopt the site plan, that may generate, oh gee, like we're doing tonight, we need to do this. Yeah. Just because we grew up together, be quiet over there.
You must have matured slowly.
So Joanne, is that something?
Yep,
you'd
she's
send
got
to
it,
us?
yep.
I've made a note, so I will send that out.
Okay, all right.
Thank you. Yeah, it's good for us to be informed of changes, because then when the public hearing happens, we don't get like jumped that night. We have some advance.
In fact, we don't have a date yet, but we already have it in our file to schedule a joint meeting like we did last year again.
Great.
And the planning board had just asked us to push it out later because right now the last two planning board meetings, it was after 11 o'clock when we get out of here. So, no offense to you guys, we're just dealing with, we got 4 subdivisions in front of us, so.
When the board receives this and individually looks at it, does the board want to review it as a board? Is that possible?
Which, the
Yeah, the
changes?
red lines, just for a discussion.
To have a ZPA work session, is that what you mean?
If
Instead of
that's
a
what you
case
call it.
hearing?
Yeah.
That
I
would be
guess,
what
I
you
guess the time to do that would be after the joint planning and zoning meeting.
Oh, I thought possibly
Oh,
before.
you think before?
Well, then.
Yeah, there's nothing says you
then we
can't.
at least go in as
Right.
as a board.
Okay,
With,
Yeah.
with common thinking and discussion between us,
that makes sense.
and compromise, we are.
Well, and especially if you're feeling that the spirit of what you are wanting is not being recognized at the planning board, it makes sense for us to come together.
And-
so
and
that
that's
we
why
have
when-
one voice saying the same thing. when
And
we're
that's how
there.
we did the 20 setback. Mike and I have been talking about this, and we did the research. Over 14 years, 86% of all cases in front of this board were for setback issues.
But how many were for
And
septic
that's-
systems?
I'd have to go back and look, Bonnie, I don't remember. There
Can-
was a
Can you
few.
do that if you have time?
What's
Like,
that?
Can you separate out any of those? None in my recorded memory were about septic. They were all about garages,
Been here longer than me.
decks, and sheds. Mostly sheds and garages.
Yeah, and that's why we passed this new 20-foot change. We didn't
Right.
do it to change our subdivision regulations, and I remember no discussion about that. I don't think the town would have supported it if they thought it was gonna change all the subdivision regulations, and
Yeah.
let people start going right to the maximum, and, once again, it affects everybody's privacy, the character of the community. So I think it's much wider reaching.
I
what
don't know
the
what a
planning board-
septic system, I
forum.
don't think a septic system affects the character too much.
Well, I
20 foot.
I disagree because,
20 foot,
because
yeah.
because what would happen in this case, if, in this particular subdivision, if they removed one lot, right, they could meet all the setbacks. So they would have a 3-lot subdivision instead of 4. And so it does affect it because it increases density. I disagree with Mr. Landry. I think you do increase density when you maximize the buildable area.
Most definitely.
I don't think so, but
And it's
Stay
a
away.
taking of the
Because
neighbors.
Because
It's
if
taking away
you've
from the
gotta,
neighbors'
if you've
privacy.
gotta put the
a
house
big
with a
issue.
more restrictive
I think the planning board.
They
sideline.
had the house, they didn't have a house, the houses, none of those houses in that subdivision were beyond the 50-foot, where they fall.
I'm sorry, what?
In that, in
All the
this-
houses were 50 feet,
All
yes.
50
All the
feet.
50,
Yeah.
but the septics weren't. Right, and that's what Kevin pointed out, is that the
But the
building
planning board, the
envelope.
planning board didn't argue, planning board accepted 20-foot septic setbacks. It's the 30,000, whether you use the house setback or the
Right.
the 20-foot setback. That was the real question.
Right.
Yeah, I'm looking for that breakdown. I have it someplace, because I think I actually broke it down into what each case,
Oh, excellent.
if I remember right.
Did we need to vote on bylaws tonight, or did we already vote on it? We just need to decide. Yep. Do I unseat Kevin? Are you offended by that? Does he doesn't get a vote then on the bylaws or not?
No, he can, because it's not a case, it's an internal thing, so yeah,
He can.
all 6 of you can
So,
vote.
okay. So I don't have to unseat him. Great. I'd like to reseat Teresa Bascom, since the case is over, and bring up the discussion of our bylaws. We had a first reading, last time we met. Yeah. And, I mean, obviously, we can't make any changes to you guys approve. I guess I'll make a motion to approve the bylaws as amended. Our April meeting.
I'll second it.
Teresa had her hand up first, and he spoke first. I don't know how you can make the decision.
I'm still reading you.
Okay,
Oh, go ahead.
all right. Do you want us to give you a few more minutes?
Are there
'Cause we
minutes-
could-
Are there minutes you guys can do?
we could do
I
that.
wasn't here, or?
I think, do we have minutes from last week?
Yes.
Sir, it's better if you guys, because I sent them out to you guys.
Oh, right. I don't remember seeing.
Okay. Mr. Chairman, I had asked you last time, and I apologize for re-asking, but
Yeah.
in the old days, we used to put a time limit on building permits, or variances that might need building permits.
Correct.
And, 6 months before, and then, I think you said that was handled in,
We have a,
via the,
that's not part of our zoning ordinance, but it's a town ordinance now, that they
okay,
automatically
so
expire
it's
after
moved
2
up,
years.
so it's automatic, and it's a year, okay.
Is it a
2
year?
years.
It's 2
2
years.
years.
If you don't use, you come in front of this board and you grant them whatever they ask for, they have 2 years to use that. If,
To start.
to start whatever it is, yeah. If they haven't started, then it's dead, yeah.
I just wanted to make sure that was.
Yeah,
still
that's covered under a town ordinance, so
Yep.
that's why we no longer make the
imposed it here.
stipulation,
Okay,
right?
yeah, yeah.
I mean,
In the
good.
old days, we used to.
Right.
but
Yeah,
now
then we
that
changed
it's
the
up a
law,
level, that's fine.
yeah. I think do we
It's
still
automatic.
remind people?
You usually do.
Yeah.
Yeah, you do, Mike, you're pretty good about that.
Yeah.
The only thing you usually remind me.
Usually
of is
30
the
days.
30-day appeal.
They all went out with the appeal face.
Okay.
So just so you know, their appeal window is, they can come back to you, they have to present new evidence.
Right.
If they come back with that appeal, you have to rule that the evidence they submit is new. If you feel it's not new, then you dismiss their application and away
Then
they
they
go, then they go to Superior Court. Or if they do submit evidence, which I don't know what that would be, and you feel it is new, then you can reopen the case and hearing. So, they'd have to reapply just like they did for tonight, so.
Right. Okay.
So we need to vote now.
Yep, voting on the bylaws, I make a motion that we approve.
I'll
And you
second that
second,
motion.
no, she already seconded.
Oh, it's
So
already
they've
been
already been
seconded.
seconded 3 times now. I get another
And
second.
a third.
All in favor?
Aye.
Aye.
Aye. 6-0. And then meeting minutes of April 19th. I make a motion to, is there any discussion on them? No. I make a motion to approve the minutes of April 19th as written.
I'll
And
second.
that,
One of us.
We gotta have Terry.
Give it to Terry.
Now, all in favor?
Aye.
Aye. Recuse or abstain, sorry.
Abstain.
Thank you. Kevin, are you abstaining from April 19th? Or were you here?
That's just what I was checking.
Yes, you
were
were.
here.
You
You
were?
were right there.
Legally, you do not have
Yeah,
to
right.
abstain if you weren't there.
Yeah,
Traditionally,
that's what
most everybody
keyed
does.
me in.
How can
I do the same
what
thing,
happened?
but just,
Where is it?
I wasn't there, I
You
don't
could
think.
ask-
well, why I bring that up is sometimes you may not have a quorum
No, I
of
read
people
it.
that night that were at that previous meeting, so we can move along. I'm going, let's, yeah, you know,
That is good.
yeah.
Yeah.
And tonight, we've got all 6 of you, so.
All right,
So,
excellent. Motion to adjourn?
Move to adjourn?
So it's been seconded, all in favor?
Aye.
Thank you, folks, appreciate it.